Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Brunswick versus Pueblo Bolo Mat. This case was heard in the Supreme Court of the United States in the year 1977. Let's go ahead and jump into the facts of the case. So Brunswick is one of the two largest bowling manufacturers in the nation. You've probably seen that name around if you've gone to a bowling alley. You've heard of Brunswick. Well, in the 70s, the bowling industry was kind of struggling a little bit. People weren't going out to bowl. So what Brunswick did was they were getting into new markets. They were acquiring and purchasing a lot of bowling alleys in areas that, the bowling alleys weren't really highly sought after. So they thought, well, this is a good opportunity for us to get bowling alleys on the low. So they went and bought 6 bowling alleys near Pueblo Bolo Mat. Well, Pueblo, is a smaller, more independent bowling alley, and they're thinking this is garbage. How are we supposed to compete with Brunswick? Brunswick is this titan. How are we supposed to compete with them? And so they say, well, let's try and bring an antitrust suit. Let's see if this is an antitrust violation. They're basically trying to monopolize the industry, and that's not fair. They can't do that to us. So we're going to sue them under Section 7 of the Clayton Act. So it's important to know what Section 7 of the Clayton Act is. Section 7 is a section in the antitrust laws that prohibits mergers or acquisitions if they tend to or may create a monopoly. So very broad language. And then Section 4 they also cited to in their complaint, and they're alleging they want treble damages. So Pueblo wants treble damages. This is a key facet of antitrust law, that damages are trebled after the jury awards them. And what that means is they're 3x'd. So if the jury awarded $100,000, then the plaintiff, if they were successful, of course, would win $300,000. So trebled damages. So Pueblo says, all right, here we go. Let's make a lot of money. They're stealing our market. They can't do this. It's a violation of Section 7. Well, the Supreme Court of the United States disagrees, and pretty vehemently they disagree. They said this isn't a violation of Section 7 of the Clayton Act. Sure, Brunswick was going in. They were buying these bowling alleys, but it wasn't anti-competitive what they're doing to you, Pueblo. It was actually pro-competitive. I'm sorry, Pueblo, that now you're going to have to compete with Brunswick, this titan, but guess what? That's what our free market is all about. It's all about competition. Our free market isn't about protecting small companies or small dealers. And that is an old idea in the antitrust laws, and really a non-economic value is that the antitrust laws ought to protect small dealers and worthy men, is the phrase that you'll see. Well, the Supreme Court says, no, that's not the aim of our antitrust laws. Our antitrust laws are meant to protect competition, not competitors. And that's one of the key quotes to glean from this case, and one of the key principles of antitrust law to glean from this case is that the antitrust laws are meant to protect competition, not competitors. And if a smaller company is going to have to compete with a larger company, well, that's the free market. And if the court said, if we were to find that this was a violation of Section 7, then we would actually be giving Pueblo 3 times of their lost profits, theoretically their lost profits, for just basically giving up and not competing. This type of competition is what's good for the folks. Maybe the bowling alleys were run down in the area. Maybe people weren't going there because Pueblo and the other market participants there before Brunswick came in weren't doing a very good job running their bowling alleys. Maybe they were dirty. Maybe the pins were old or broken. Maybe their bowling balls were garbage. The shoes smelt poorly. They stank. Well, if that's the case, Brunswick coming in is going to make it more competitive. And Pueblo, you're going to have to get with it. You're going to have to get up and at it. So that's the key holding is that, if it's not an antitrust injury, and that's the key phrase, right? Antitrust injury. Pueblo did not have an antitrust injury because they weren't injured by this alleged monopoly. Brunswick didn't have a monopoly. They were really just forced to compete. And our antitrust laws are intended to protect and force competition. And so, although it might look like Pueblo had a good antitrust case, in fact, they did not. This precedent could be somewhat problematic, and I think we've seen this type of laissez-faire, hands-off approach lead to some different types of companies in our free market, namely Facebook, Google, these large tech companies, Amazon. No one can really compete with them, but these large companies can provide goods for a better price, and they can do it more efficiently. And so there's this problem that's created when you take this approach that the court did in Brunswick, where we might have large firms that are able to produce more efficiently, and they might be buying up smaller competitors, but if they can still produce more efficiently and give the customer a better price, is that an antitrust problem or is that not? And that's something that antitrust law is clearly grappling with at this moment. But it is kind of interesting to look at, early guiding principles of where that came from and where it's taken us today. So Brunswick Corporation versus Pueblo. Thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.